Hi, everyone. Thank you so much for joining us today to talk about the very hot topic of data protection in investigations. I'm Rachel McDonnell. I'm a partner in the disputes group at mills&reeve. We're here today to talk about data protection and investigations. And at M&R, we regularly work on lots of different types of investigations in many different guises, whether that's assisting with and advising on internal investigations into potential crimes, economic crimes or otherwise, or conducting third-party workplace investigations, or dealing wholly with external investigators. All involve similar but different considerations, and in particular, different data protection issues and procedures. And that's really what we're here to talk about today. Just before we start, just a few housekeeping points. If we move to the next slide. This is going to be a recorded session, and we will make the presentation available afterwards. Please do drop us some questions in the Q&A box below. Don't be anonymous in case we don't have time for all your questions. We will try and get to as many questions as we can at the end, but if you do want to contact us separately, please feel free to do so. And finally, just a bit of a plea for feedback when the session ends. It really does help us shape our next sessions and our programme going forwards, because as you know, we do these sessions monthly and we're always looking to hear about what you're interested in learning more about. So I'm joined today by Claire Williams and Alistair Duggan, and I'll let them introduce themselves.
Thanks, Rachel. So my name is Claire Williams. I am a senior part of the contentious data team here at mills&reeve. So we deal with all aspects of GDPR.
And hi, everyone. I'm Alistair. I'm a senior associate at mills&reeve. I have a particular focus on technology and data protection and other commercial contracts and commercial law issues. Day to day, I advise organisations on a range of commercial matters, including the uptake of new technology such as AI and data protection and compliance, including the points we're going to discuss today. Thanks.
Thanks, both. Should we kick off?
Thank you. So our first part today is the potential risks from a data protection perspective. So when you're planning and structuring an internal investigation, you have to make a series of critical decisions to ensure that personal data is being handled lawfully, fairly, and securely. And these decisions aren't just procedural, they are central to maintaining compliance with the UK GDPR and protecting the rights of individuals. So key data protection related decisions must be addressed at the outset, although data protection compliance is also something you have to continuously monitor throughout the investigation process. Decisions include identifying the lawful basis for processing personal data, determining whether a data protection impact assessment or a DPIA is required, and establishing clear access controls to maintain confidentiality. Organisations must also decide how they're going to manage data subject rights, such as access, rectification, and erasure, which could be invoked by complainants, respondents, or witnesses. Other important considerations will include defining the scope and purpose of data collection, ensuring transparency through appropriate privacy notices, and setting clear retention and disposal policies for investigation records. Where you're involving external parties, you'll have decisions around data sharing agreements and contractual safeguards. They're also essential. And each of these decisions carries legal, operational, and reputational implications. Poor planning and oversight will lead to delays, regulatory scrutiny, legal claims, or investigatory failure. So in this session, we're going to throw a fair bit of data protection terminology around. So it's a bit important to check that we're all on the same page in terms of that terminology. So quick slide for you. The data controller is the one in control of the data. They're the decision maker. They decide what is going to be processed, how, and why. Personal data is anything relating to an identifiable living person. That person is the data subject. And special category data is the personal data that could cause issues for a data subject if it gets out in an uncontrolled way. So that includes data regarding race or ethnicity, their beliefs, their health, their sexual orientation, things like that. You also need to be aware of the key GDPR data protection principles. So there are 6 of them under the UK GDPR, and these are that data must be processed lawfully, fairly, and in a transparent manner. It must be collected for specific, explicit, and legitimate purposes. It must be adequate, relevant, and limited to what is necessary for those purposes. It has to be accurate and must be kept up to date. It has to be kept in a form which permits identification for no longer than necessary. And it has to be processed in a manner which ensures appropriate security. Now, there's also an unofficial seventh principle, which is accountability. And you need in all cases to be able to demonstrate your compliance. In the context of an investigation, every single one of these principles may be invoked at one stage or another to challenge your investigatory process. And as such, you need to have thought through the data protection aspects very carefully, even before you appoint an investigator. Really, you need to think about it now, while the investigation isn't even in prospect, because that will help safeguard your position when the day finally arrives. As they say, proper planning prevents poor performance, and that is definitely true here. But first, let's discuss what's at stake. If data protection and data is mishandled during an investigation, your consequences can be very serious and wide-ranging. From a legal standpoint, organisations risk breaching the UK GDPR and other applicable laws, including, for example, those related to surveillance. It's no secret that data subjects who believe that their personal data has been mishandled can bring a claim for compensation in the courts. Such claims may not individually be worth much, but the time and cost of defending them can be very significant. Claimants might be persistent, and it is notable that much of the UK data protection legislation is relatively untested in the courts, meaning that outcomes cannot always be accurately predicted. Nobody wants to be the test case, and the more that you do to ensure appropriate data governance within and around your investigation, the lower the risk will be for you. Regulatory risks also arise when investigations fail to meet data protection standards. Both personal data breaches and breaches of the principles, as discussed on the previous slide, can lead to enforcement action by the Information Commissioner's Office. Data subjects are able to complain directly to the Commissioner, and although its complaints process moves very slowly, it does still move. ICO enforcement can include fines, enforcement notices, audits of your data governance, or even criminal sanctions in extreme cases. Regulators may scrutinise whether a data protection impact assessment was conducted, as well as whether data subjects were informed appropriately and whether safeguards were actually in place for sensitive data. The financial impact of errors can also be significant, not just from the fines and legal costs or compensation claims, but also regarding the resources that have to be diverted to deal with the complaints, whether justified or not. If personal data is exposed or misused, an organisation may need to invest urgently, for example, in crisis management and compliance improvements. Operational risks may arise, including disruption to business processes, loss of employee trust, and delays caused by having to redo or halt investigations entirely. So mishandling data can compromise the integrity in the investigation itself, making your outcome unreliable and legally challengeable. And finally, reputational damage can be severe. News of a poorly managed investigation or data breach can erode stakeholder confidence, it can damage employee morale, and it can attract negative media attention. So in today's digital age, reputational harm spreads quickly and it can be very difficult to recover from. So in short, getting data protection wrong in investigations isn't just a compliance issue, it's a strategic risk. Turning to look at the data protection related claims you may face if things are not properly planned for, the most likely is a claim under the UK GDPR. Under the GDPR, individuals can seek compensation for both material and non-material damage resulting from unlawful data processing, and that includes distress and anxiety and reputational harm, even if no financial loss has ever occurred. Beyond the GDPR, mishandling personal data may also give rise to claims for breach of confidence, particularly where sensitive or confidential information is disclosed without proper safeguards. Similarly, individuals may pursue claims for misuse of private information, a tort recognised under English law that protects against unjustified intrusions into your personal life. You may also have negligence claims that arise if an organisation fails to take reasonable steps to protect personal data during an investigation, especially where foreseeable harm results. So, for example, sending sensitive information to the wrong recipient or failing to encrypt communications could be seen as a breach of a duty of care. And in more serious cases, particularly where investigations involve things like surveillance, profiling, or discrimination, public authorities may also find themselves the target of claims under the Human Rights Act, such as breaches of Article 8, the right to respect for private and family life. Now, damages awards under these various claims vary wildly, as they are all context dependent. So, for example, there's a case called Grinya and Plymouth Hospitals Trust from 2012, where the county court awarded damages of over £18,000 to a claimant. The claimant in question, his previous partner was a nurse and had unlawfully accessed his medical records, then used that information to attend his home or his family's home and speak to them about him. So the breach exacerbated a pre-existing serious mental health condition, caused associated financial losses and considerable distress. So he got £18,000. Note that does not include any fees. In contrast, there was a case in 2022, Driver and the Crown Prosecution Service, where the CPS provided an update on the possible prosecution of Mr. Driver to a member of the public. There was no reason whatsoever for them to provide the update to that individual, who then used it in a political campaign against Mr. Driver. So the court found a breach of data protection principles had occurred. However, despite anything, Mr. Driver only got £250. As you see, they vary wildly in terms of how much you get. But while courts are cautious about trivial claims, significant breaches, especially those involving sensitive data or systemic failures, can lead to substantial liability. Even responding to seemingly trivial matters can cost a significant amount of money. And a claim that would be valued at £250 may cost a lot more to settle when legal fees are taken into account. Alternatively, you could allow it to go to trial as a small claim, which may reduce your liability for the other side's legal costs, but that might be offset by your own rapid increase in your own legal costs and time costs. So organisations need to ensure that data protection is embedded into every stage of their investigation process. And it's not just claims that you need to be prepared for either. During investigations, individuals involved, whether as complainants, accused parties, or witnesses, can invoke their data subject rights under the UK GDPR in ways that may disrupt the process or undermine its outcome. So these rights, while essential for protecting personal privacy, can be strategically used to delay, derail, or challenge investigations. So, for example, a complainant may submit a subject access request seeking all personal data held about them, including emails, meeting notes, and correspondence related to the investigation that they have triggered. Responding to those requests can be resource intensive, may expose sensitive information prematurely, and could potentially influence the investigation's direction. An individual accused of misconduct might request rectification of data they claim is inaccurate, or erasure of information they argue is irrelevant or unlawfully processed. And while these rights must be respected where they do apply, clearly they can be used to challenge the inclusion of key evidence or to cast doubt on the integrity of an investigation. Even disgruntled witnesses may try to object to their statements being used, or they may submit subject access requests that complicate the handling of any testimony they give. And if their concerns are not managed sensitively, they may withdraw cooperation or raise further complaints that trigger further scrutiny. Ultimately, while data subject rights are fundamental, organisations must be prepared to manage them carefully during investigations. Failure to do so can lead to delays, procedural flaws, and outcomes vulnerable to legal or regulatory challenge. So you need a robust data protection strategy to uphold fairness while maintaining integrity. So moving on to look at the key decisions for navigating data protection risks when you're planning an effective investigation. When planning and structuring an internal investigation, you have to make a series of critical decisions to ensure that personal data is handled lawfully, fairly, and securely. These decisions are central to maintaining compliance with the UK GDPR. The key data protection related decisions must be addressed at the outset. Data protection compliance is also something you must continuously monitor. You have to think about how you're going to manage the data subject rights, as I say, the scope and purpose definitions. You need to ensure transparency. So on our next slide, which is going to be shared with you after the seminar, we have created a handy go-to reminder. There are lots of ways to carry out an investigation. Investigations into employees or their grievances are often conducted by HR, but that might not be appropriate where HR is the target of the grievance or there is a risk of bias. So your first question is going to be, who will the investigator be? Perhaps your organisation is small and you're going to need external support because you don't have internal resources to handle it. Equally, the situation may be sufficiently sensitive or legally thorny that you're going to need lawyers to do the investigation for you and guide you through the potential traps. We're not going to dwell on the pros and cons of your options in this session. I'm afraid we don't have time for that, but we can help you in that if you do require further advice. But if you're going to use an external investigator, you will then need to consider whether or not they will be acting as a data processor or a data controller when carrying out their task. So that's something we're going to cover on the next slide. Once your investigator has been settled, the next critical question is what exactly is going to be investigated and why? So these questions might sound straightforward, but they require careful thought and clarity from the outset. Personal data may only be processed for a specific purpose. You will need to define the scope of the investigation precisely. The scope will determine what evidence is relevant, which individuals are involved, and what data needs to be collected. So putting it a different way, what personal data will be processed and from whom and where it will be obtained. A vague or overly broad scope can lead to confusion, wasted resources, and legal challenge. But conversely, a scope that's too narrow can miss critical context or fail to address root causes of issues. A key principle of data protection here is that of purpose limitation. You are not permitted to use personal data other than for the purpose for which it has been collected, or those closely related purposes, hence your need for clarity at the outset. You also need to be clear as to the why of the investigation. Is your aim to establish facts, determine accountability, resolve a grievance, or comply with legal or regulatory obligations? The purpose will shape the tone and reporting of the investigation, as well as the potential outcomes. Being clear as to the why will also help you frame the question you're asking and thereby ensure you don't exceed your jurisdiction. An investigation into something that you don't really have jurisdiction over is fairly likely to be beset with data protection issues. Data protection law, also, and the extent to which you are expected to go to comply with it, depends on multiple factors, including the potential impact of the processing on the data subjects. A greater degree of care and attention is expected where the outcome could be high stakes. So if someone is likely to get fired, to have their income removed, or have their reputation destroyed, you are expected to do far more to safeguard them and their data rights than in a case where the outcome will be essentially a slap on the wrist. Moving on, now you've clarified who will lead the investigation and what and why it's being undertaken. The next set of decisions addresses logistics, methodology, and involvement, each with important data protection implications. Timing affects urgency and risk. Delays may increase the likelihood of data loss or unauthorized disclosure, but rushed investigations may overlook key data protection safeguards. Decisions made on inaccurate, outdated information are more prone to being challenged, and use of that information has the potential to breach the GDPR principle requiring accuracy. A point to note here also is that computer access logs may only be available for a limited period, and the same goes for CCTV. Location matters too. Will interviews be conducted remotely, in person, or on site? If remote, how will you prevent interception or unauthorized access? If physical documents or devices are involved, how will these be stored and transported securely? These decisions directly impact the principle regarding data security. There's also the question as to whether your investigation involves data crossing any international borders. If you're collecting personal data from individuals located outside the UK, you may find that data protection regimes other than the UK GDPR also apply. And in such cases, it's very wise to document the data flows occurring so you can properly understand your obligations. Your investigatory methods, such as interviews, document reviews, or digital audits, must also be proportionate and legally compliant. You'll need to assess whether personal data will be collected directly or indirectly, and whether any special category data, such as health, ethnicity, union membership, etc., is involved. Remember that your processes must align with the GDPR principles of lawfulness, fairness, and data minimization. You should also plan how data will be recorded, stored, and analyzed, ensuring that access is restricted and audit trails are maintained. All of these things can be points at which data subject can pick at, and we have seen it in action. And it just causes an awful lot of upset for an investigation, which is already a trying time. There's also a question about who else needs to be involved. Involving others, whether they're HR, legal advisors, IT, media support, external investigators, it all requires careful consideration of data sharing and role-based access. If third parties are engaged, you need to ensure that you put in place appropriate contracts or data processing agreements. Alice is going to talk about these in more detail shortly. The need for appropriate contracts includes contracts with your investigator. A simple letter of instruction that does not contain appropriate data protection clauses is no longer likely to be sufficient in this day and age. Internally, you also need to clarify who's going to have access to investigation data and under what conditions. Data subjects, particularly but not only those accused of wrongdoing, often try to allege that their data has been improperly shared. We have seen the targets of complaints use data subject access requests to try and gather information showing that sharing has occurred, and then they seek to derail investigations by challenging all the data sharing that has occurred, whether internally or with an external party. If you determine in advance who should be involved and why, you are much more likely to be able to brush off these sorts of challenges. Clarity in this area helps uphold the principles of integrity and confidentiality, and it also ensures accountability throughout the process. Finally, on this slide, and somewhat surprisingly for many, we find you need to identify at the start, where at all possible, with whom are you going to share the outcome. And this decision has significant data protection implications, particularly around confidentiality, purpose limitation, and lawful disclosure. If you don't identify the likely recipients of the outcome or verdict at the start, and you have not been sufficiently transparent with data subjects, you may actually find you cannot lawfully share the information with the ones you want to share it with. You also need to consider the way the outcome is reported. Not all reports as they are drafted are suitable for sharing with just anyone. So think about how you want it to look at the start so that the investigator knows what they're aiming for. If your investigation was, for example, to pacify your lenders or report to a regulator or allow you to publicize the facts of what has occurred, it may all have been for nothing if you didn't make it clear who you were going to share it with at the start. It would be an expensive exercise that fails to give you what you need. Now, as I mentioned, you need to know if your investigator is acting as a data processor or a data controller when carrying out their task. For internal investigators, they are a part of your organization, so there's no data transfer to another processor or controller. You count in law as one and the same thing. However, external investigators can fall into either role depending on the level of control that you as data controller exert over their activities. And it's not always straightforward to determine whether an investigator will act as a controller or a processor. In the investigations we've acted on, there have been examples of investigators acting as both roles, clearly not at the same time. It's the case that an investigator will be one or will be the other. Now, we've listed on the slide some factors that are useful to ask in determining whether the investigator will act as a processor or as a controller. So who will decide which individuals to collect the data about? Who determines the purposes for which the data is going to be used? Is the instructing organization going to have the automatic right to access all that personal data generated by the investigator? To what extent will the investigator have discretion to make decisions? To what extent will they be expected by the organization to follow instructions as to how data will be processed? And at the end of the day, will the investigator retain the personal data collected or that they have generated, or are they going to be required to give it all back? And it's key to establish the answers to these questions at the outset, as we say, because it will determine the form of documentation required, and it will establish what the key roles and responsibilities of the investigator are in relation to the investigation. In more general terms, it's useful to think of this as thinking about the degree of autonomy that your investigator will have, and that will determine whether they are a processor or a controller. Investigators who have the scope to determine what data to collect and who should be interviewed may well act as a controller because they are determining the purposes and means of processing. Common examples that we've personally seen of this are barristers when appointed as an investigator. They have wide scope and they tend to be controllers. Alternatively, if the investigator is acting on a very clear set of defined instructions, they are not allowed to go outside of those parameters, then it may well be a processor. So your terms of reference are really, really important here, but it's not just your terms of reference, it's also how things pan out in practice. What the papers say is one thing, but if you then do something completely different, you may find there's an awful lot of confusion as to what roles are being played. And it's not always the case that all the factors will point to the same answer. You have to review all the relevant factors in the round and in context. Organisations instructing investigators may also have a preference for a certain type of role. It depends how much control you wish to maintain. If you want the investigator to return all the personal data after the investigation and to only share the data if you tell them that they can, it may be preferable to set this up so that the investigator is definitely a data processor. And they can only act within the parameters of your instructions and go no further. So as foreseen, there are going to be documents to complete in order to get all the paperwork in place. As I mentioned earlier, there is a seventh data protection principle being accountability, and the creation of the right records and documents along with actually using them is how you prove you have done it all correctly. So I will now hand over to Alistair to take you through the main documents that you will need.
Great, thanks very much, Claire. So I'm going to discuss the data protection documents that you need to put in place in order to ensure a lawful investigation. I'm focusing primarily on where an investigator is appointed as an external investigator, but I'll also try and touch upon where this may differ when you're doing an internal investigation as well. So in terms of the key points I want to really put across today, the first is that it's really important to consider the key factors early and make those decisions early, and this will really make your life a lot easier in preparing the documents. So all of those points which Claire touched upon, is the investigator going to be a processor or a controller? Who will need to receive the data and the outcome of the report? And if you can determine these points at the outset, the preparation of the documents will really become a lot easier. The second point is that timing is likely to be key. The investigation may have already decided to go ahead when you know that you need to prepare the documents, and often it can be quite time sensitive in terms of when you need to prepare these documents by, as witnesses may be waiting to be interviewed, and there can be issues if the investigator carries out an interview before the documents are set up. So it's really important to consider, do we need these documents early, and so that you can then make the decisions quickly in order to get that done. The third point is really that it's quite important documents correct, as unlike some data protection documents where you think it might just be that we need to put them in place and they might not be looked again. Often we find that these documents are scrutinized quite a lot in investigations, as it can be that there's quite a lot at stake for the individuals involved, and also it really creates confidence if documents are put in place and there is full transparency to the people who are going to be involved in witness statements, for example. And then finally, in terms of the key points, there's nothing really novel about the documents I'm about to discuss. People who are familiar with data protection documents will know about these documents, but there are elements of the content that are really specific to investigations. And so hopefully we can kind of give you a flavour of the things you really need to think about today. Could we have the next slide, please? Yeah, so the key documents when appointing an external investigator there, the privacy notice is really the main one in terms of transparency to people involved in the investigation. And I'll come into that in a bit more detail later. And then we also have the data sharing agreement or data processing agreement. And this will go back to the decision as whether the investigator is going to be a controller or a processor. You're likely to need one of these documents depending on that decision. And then also in certain circumstances, you may also require a data processing impact assessment. This will be where the processing is likely to be high risk. So it's not always the case that you will need this document, but we'll try to touch on a little bit when you will need this. And if you do need this document, then it's quite important to get that done early, as that will kind of create the information you need to prepare the privacy notice or data sharing agreement. Next slide, please. So, as I said, the privacy notice is really the key document to ensure transparency to individuals participating in the investigation, such as the witnesses or anyone being investigated. This should really be provided to individuals before any interview is carried out, as not doing so can create issues down the line. And while organisations may have existing privacy notices that cover employee investigations, we found that in sensitive investigations, it's really preferable to put in a specific privacy notice for that investigation, or potentially to supplement your existing privacy notices with additional information for that investigation. And this really gives confidence to those people who are involved in the investigation that their data will be handled lawfully and knowing exactly what is going to happen with that data. I've underlined on screen some of the areas that are likely to require specific thought in the context of an investigation. So taking those in turn, we've got types of personal data. Some of this will be very obvious. So you're obviously going to need to collect names, for example, and employment information, whereas other types of personal data will really be specific to the investigation that you're carrying out. For example, you might need to think about whether you need to collect any photographs of individuals. Do you need data around their race or ethnicity? And it's really important to try and limit this to what is relevant for the investigation, while still giving enough flexibility to ensure that if additional information is provided in an interview, for example, your privacy notice doesn't limit you to what you can collect for the purpose of the investigation. The second one on the screen is lawful basis. So this will obviously need to be considered in the context of the specific processing that you're carrying out for that investigation. It may be that your organization has a legitimate interest in processing the personal data for that investigation. We do find that it's very unlikely that consent will be appropriate for as a lawful basis for these types of investigations, as in the employment context, it's unlikely to be able to show that it will be freely given. And also, if you did use consent, then the data subject would need to be able to withdraw their consent at any time. In terms of Article 9 basis, you may need to collect special category data, which also requires an additional lawful basis under Article 9. And this might happen, for example, if you need to collect data relating to their race or ethnicity, or data related to their health. And in that case, you would need a privacy notice to set out what this additional basis is under Article 9. And you might also then need to refer to Schedule 1 of the Data Protection Act, which would set out that basis. Then, as Claire mentioned earlier, it's really important to consider who the data will need to be shared with. This really creates transparency to the individuals, and also thinking about what the outcome of the report will be, whether that will need to go to any third parties. If you set that out in your privacy notice, then you ensure that there is full transparency at the outset on that. And then finally, thinking about data retention, it's important to think about whether there might be a possibility of litigation as a result of the investigation. So obviously there could be quite high stakes involved for the individuals. So if there is any litigation that results from the investigation, think about what the limitation period could be for that claim, and then making sure that you set that out in your privacy notice and what data needs to be retained for how long. Could we have the next slide, please, Claire? So the next document which you may need to have set up is the data sharing agreement. And this would be if the investigator is being appointed as an independent controller. So this, again, goes back to the decisions that you need to set out early. And this document will set out the parameters of data sharing on a controller-to-controller basis. It should comply with the ICAO's data sharing code of practice. And the status for that code is that you either need to be able to comply with that, or you need to be able to explain why you haven't complied with that if there was a query from the ICO. And this code of practice is really useful because it kind of sets out the types of things that would need to be included in this document. It's likely to cover similar points to those which are set out in the privacy notice. So again, you would need to think about how all of your documents align, thinking about your terms of reference, your privacy notice, and also either your data sharing agreement or your data processing agreement. So it would include things like the purpose of sharing, the lawful basis, the types of data you're collecting, how data subject rights will be dealt with, and also the security measures of the investigator. And in terms of the form of the document, it may be linked to an overarching agreement, such as the investigation services agreement, or it could also be annexed to the terms of reference. And we've also seen other examples where you might send the data sharing agreement as a letter to the investigator and just ask for them to sign their agreement to that. And that can sometimes go down quite well for the investigator in terms of being able to accept that document rather than having it as a standalone agreement. Could we have next slide, please? So if the investigator is appointed as a processor, then you would need a data processing agreement instead of a data sharing agreement. Data processing agreement has to set out all of the points covered by Article 28 of UK GDPR. These are legally required points when appointing a processor. I'm not going to run through all of those on this seminar, but I did want to pick out a couple of points which you might need to think about in terms of an investigation. And the first of those is thinking about what security measures the investigator will have in place. So it's really important to know that the investigator is going to put in relevant measures in order to protect the data. So thinking about, will the data be password protected? How will it be transferred to the instructing organization? And also you can often ask the investigator to set out what security measures they have themselves in this document. So this can help form assurance to you that they are taking data protection very seriously. It's also important to consider, does the investigator have any sub-processors? It's likely that you wouldn't want a lot of people to have access to really sensitive data of an investigation. So the data processing agreement would set out who the sub-processors are and also have a consent mechanism for if the investigator needs any further sub-processors. And this would also help flesh out where the data is likely to be stored. So is it going to be stored in the UK? Is it going to be stored on servers in a different jurisdiction? In which case, does that jurisdiction have levels of data protection similar or same as the UK? And then finally, it's also important to think about what is going to happen at the end of the investigation. Will the investigator retain the data, or will this be provided back to you, the instructing organization, and then deleted by the investigator? So all of these points in the data processing agreement can really give you protection on these. Next slide, please. The final point I wanted to cover and just touch on quickly is the data protection impact assessment. So you would only need to do this if the data processing is likely to result in a high risk to the rights and freedoms of the individuals involved. I'm not going to dwell on this long, but it's just important to consider whether a DPIA would be needed in the context of your investigation. You'd have to carry out an initial screening at the outset to consider whether it's likely to be high risk. There is quite detailed guidance from the Information Commissioner's Office on this, although the UK GDPR doesn't actually set out a definition of what high risk is. There's many factors which the ICO would consider as indicating that the data is likely to be high risk. So standard investigations that you'll do often within your organization, such as HR complaints, are unlikely to result in a DPIA. But if there's really high significance to the consequence if there's high significance to the individuals involved, such as serious consequences for their future employment or personal lives, then it's likely that a DPIA should be required at the outset. And if you do decide that a DPIA is needed, then we recommend doing this document as the first document out of all of them, as this will set out the information that can be used to complete the privacy notice and also the data sharing agreement or data processing agreement. Next slide, please. Just coming back to all of the key factors again, I just thought I'd put them back up on screen just to remember all of these points. Again, it's really important to consider things early. It's important to get these documents right, as they may be a high level of scrutiny of the documents. And also there's nothing really novel about the documents themselves. So privacy notice, data sharing agreement, or data processing agreement, you may have standard templates of these documents within your organization, but just doing this all early is really key. That's mine.
Thanks so much, Alistair and Claire. You've given us lots of different things to think about there. We've had some questions, and we'll try and get to those in the time we have available. One of them is, are there any protections which organisations can have in place from data subject rights which are obviously intended to be in place from data subject rights which are obviously intended to be disruptive to or derail investigations? So what protections could organisations have in place?
Yep, no problem. So in terms of data subject rights, they are very, very wide ranging, but they come with some qualifications. Some of the wider rights, such as the right to object and the right to erasure, they will only apply in certain circumstances. So your protection there is really to look very, very carefully at the actual legislative provisions, because we tend to find that people demand their data is erased, for example, and we can often just write back to them and go, yeah, sorry, you actually don't have that right in this situation. There are also a number of exemptions to the various data subject rights that are set out in the legislation. There's an entire schedule full of them. because it is appreciated that people actually do need to run investigations, they do need to process the data. There are also, for data subject access requests, which is the most commonly used right, there is an ability for you to refuse to comply with the right in the event that the request itself is what's called manifestly unfounded or excessive. You will need further advice on whether those apply. The ICO does not like it when we invoke them, but we are finding that they are having to be invoked more and more and more, because people have woken up to the fact that they can use these rights to throw a spanner in the works.
Yeah, we see more of that in all investigation contexts, I think. One of the questions we have is around, we talked about supplementing data privacy notices, for example, for employees. In some circumstances, you're not necessarily going to give notice of an interview to an employee. So how does data protection issues work in that context?
So this one would be this would be why you need to sort of think about it now while your investigation is still a mere twinkle in your eye, because you need to make sure that your employee privacy notice is sufficiently broadly drafted to cover the kinds of things you're probably likely to be investigating, and to cover the kind of data sharing you might want to do. So unless it's a very, very unusual investigation, you can normally create a privacy notice that will cover it in a very broad brush manner. And that is essentially the best that you can do. But as long as you have something in your privacy notice that you can point to when they complain and say, well, I didn't know you were going to do that. You point to it and say, well, we did say, we told you that. You had to read the privacy notice though.
Mm-hmm. I've had a couple of questions for you to reconfirm the name of the 2012 case where there was an unlawful access of records. Claire, do you remember that
Oh, my
the name
memory.
of the case?
Grinya and Portsmouth Hospitals NHS Trust.
And a couple of, just leading on from your question here, the earlier question, can you give some examples on what might be considered manifestly excessive or unfounded?
So manifestly unfounded is, for anyone who's in a public authority, it's quite similar to a vexatious requester under the Freedom of Information Act. So it's somebody who's not using the right for the purpose it is supposed to be used for. Bearing in mind the purpose of the right is so people can understand what data is being processed about them and ensure that it is being processed lawfully. So if it's very clear that they are doing this not to find out what you're processing, but to interfere in the investigatory process or in some sort of retaliatory way, or as part of a campaign targeting other employees, for example. There is a list on the ICO's website of things that might apply. The list is quite limited, but you also, as I said earlier, the data protection law is very untested in the courts. The ICO guidance, as helpful as it may be, is not necessarily the final word on what is covered. So if you can articulate an argument, and you would be happy to put it before a judge to say that this is manifestly unfounded because this person's being unreasonable and clearly trying to interfere, then my general position is that you might as well put that argument forward, because the worst that can happen is that someone tells you you're wrong and you're going to have to go and process the request a year later.
Thanks, Claire. I think we're running out of time now, so apologies if we didn't manage to get to your question. Please do follow up with us afterwards if you'd like. And also a bit of a plea for feedback, please. How did we do today? What would you like to hear more about? There's a survey coming to you shortly. And finally, we've got our next event on the 22nd of October, and Claire's got a bit to say about that.
Yep. So our colleagues Katrina Anderson and Sam Wigley will be having a look at dark patterns. They're going to explore the growing legal and regulatory scrutiny of manipulative online design practices. That's what dark patterns are, or online choice architecture. So that session is going to provide you with some practical insights into how businesses can identify and avoid these practices. And they're going to be focusing on the legal definitions and real world examples and the key legislation, and also the enforcement trends, which will of course be very important to you. So please do join us for that session.
Fantastic. Thank you. Thank you everyone for joining today, and we'll see you all again soon. Thank you.